right, just a minute. So Anna, you do have a quorum. If you want to call the meeting to order, then I'll read the governor's notice.
Certainly, I will call the meeting to order the meeting of January 7th, 2026.
This is the Bridgewater Zoning Board of Appeals pursuant to Governor Baker's March 12th, 2020 order superseding certain provisions of the open meeting law, which is general law, chapter 30A, section 18, and the governor's March 15th, 2020 order imposing strict limitation on the number of people that may gather in one place. This meeting of the Bridgewater Zoning Board of Appeals will be conducted via remote participation to the greatest extent possible. No in-person attendance of the members or the public will be permitted, but every effort will be made to ensure that the public can adequately access the proceedings in real time. This meeting is being recorded, and within 48 hours, we will post a link of the recording on the town's website or town social media. The following members of the Bridgewater Zoning Board of Appeals are participating remotely. Anna Klimas, who is sitting in as the chair, Dan Greenberg, member, and Amanda Mattel, member. Members of town staff are Nicole Salvo, Assistant Town Planner, and myself, Bob Rowley, Director of the Office of Community and Economic Development. During this meeting, all votes will be taken as roll call votes. At this time, everyone's mic is muted. The board's mics will be unmuted through the whole meeting. As items appear on the agenda, the project representatives' mics will be unmuted. If the project is a public hearing and allows for public comment, we ask that you use the chat feature to ask your question by listing your name and address in your question. The chair will recognize all questions in order. You can also use the raise my hand feature in the participant menu, and you will be unmuted when the chair recognizes you. Again, please state your name and address before asking your question. If you are on the phone, you can dial 9 to raise your hand. So that is that.
So there are two items on the agenda today. The first item would be a modification request for 85 Plymouth Street, or Dwell 85. Who do we have representing that project? Jeff? I think you're unmuted.
Can you hear me?
Yes.
Yes.
Okay.
Can you just state your name for the record?
Jeffrey Engler, representing the petitioner, the applicant, SLV Bridgewater PO.
Okay.
I'm also joined by my counsel, Stephanie Kiefer from Smollett and Vaughn, as well as my partner, Justin Krebs.
Good evening.
Good evening.
Good evening.
Madam Chair, are you turning over the floor to me, or would you like a statement,
Yeah.
or how would you like to proceed?
Well, we got your request, and so yes, I will turn the chair. I will turn the floor over to you. I'm a little. Yes, I'll turn the floor over to you.
Okay. Thank you. Appreciate it. For members of the board, my name is Jeff Engler. I represent the applicant. I have an ownership interest in the applicant. I've been involved with this project since its outset, since its original filing with the Bridgewater Zoning Board of Appeals. We're here to you tonight asking for a modification to our existing permit. Put simply, we're simply asking for a waiver to be granted relative to the lodging house provision that was enacted or was in place, I should say, back in 2018, 2019, when we made this original application. This has risen to an issue with the building commissioner that it was never brought to our attention during the hearing. We never thought it applied. This is a multifamily apartment building. We've now been in operation for 4 years, plus or minus. The intent was always to have units that are rented by the bed to students at Bridgewater State. In fact, we currently have a master lease with Bridgewater State, and they're very happy to have students at the university rent with us. So to put it simply, we do not believe the lodging house provision ever applied here. It was never brought to our attention. I could call up the plan set that was approved by the zoning board that shows our intent to rent by the bed. It was clearly marked on all the plans. We had a sample lease. I can go into as much or as little detail as you like, but long story short, after we opened up, the building inspector made an issue of it, said we were a lodging house and we were in violation of that provision that we have for unrelated people in certain units, which we agree to. In certain cases, we have 2 bedrooms that have 4 beds that have 4 students in them. We are operating successfully. We have had no other than some initial bumps back in 2021 when we originally opened. We think we're a vibrant and important part of the Bridgewater community. We think the university agrees with that. So we're here tonight just simply to ask for grant of this waiver to the lodging house provision, which once again, we do not think really even applies, but we've been told by the town that it does. And thus we're here before you tonight on that single issue alone. So with that said, I'd be happy to answer any questions or go into additional detail. I also have the original plan set that was approved by the Zoning Board of Appeals that can confirm some of the assertions that I made in these comments.
Thank you.
Go ahead.
Go ahead, Ron.
Jeff, how is this different than what is currently being litigated?
Well, I'll defer to my counsel on that, but basically that originally we were asked, we had an administrative appeal to the ZBA when an executive order was issued by the building commissioner. So we went to the zoning board. This is going back 4 years for their interpretation. They agreed with the at that time the previous board with the building commissioner, and at that so we moved forward with our legal rights as is allowed under the law. We've recently had a hearing before the Superior Court, and the justices, the panel that we appeared before, said, and I'm paraphrasing, why don't you just go back to the zoning board and get a waiver from this provision, because that's really the only issue and point of contention. So that's kind of where we're at, but there are different venues, there's different processes in their entirety, and thus we're before the zoning board under a different, or we're before you tonight under an entirely different process than the one that's going on before the Superior Court.
But
Steph,
if in fact the ZBA hypothetically was to agree with what you're asking, the litigation then goes away?
Correct.
Yeah, I mean, I think that's, I won't speak for the members, but I think that's where their level of uncomfort begins. But I'll let them, speak to that.
Stephanie, maybe is it worth you going into just the legal differentiation between the two and how they are separate, and really log on how this was through the comprehensive permit and why the request for a minor modification is in the approach that we're taking?
Yes, and if I may, good evening, members of the board. Stephanie Kiefer from Smolik and Vaughn. I have appeared before the zoning board on this project for prior modifications. I'm not certain any of you were sitting on the board at that time. I specifically recall there was a scrim that we had sought a minor modification for, but nonetheless, to answer the question that's been presented, the appeal process that's currently within the court system was, as Jeff had indicated, the building commissioner had issued a cease and desist. And so he had issued that. And so it was an order that needed to be appealed then pursuant to the processes under 40A. This is a little quirky here, but the comprehensive permit obviously was issued by this board pursuant to Chapter 40B. So that process has, went to the Superior Court and then has went to the appeals court. I'm not the attorney of record in that matter. However, within the 40B process, and I believe that it was actually mentioned though within the appeal of the enforcement or the cease and desist matter, but as a matter of 40B, an applicant can come back to the board and request for a modification. And so the very point of the request that was submitted the other week and why we're here this evening is, as Jeff had explained, it doesn't appear clear that the what had been the lodging provisions of the zoning bylaw that were in effect at the time the comprehensive permit application were applicable. And you know, the owner of the property still thinks that they're not applicable. But to kind of address the matter forthright, we're coming before the zoning board under 40B, who issues the permit, and it's comprehensive of all local approvals, to say that if in this board's opinion that this lodging house somehow applies to these tenancies that may, for some of the apartments, be rented to more than 3 unrelated individuals, then we would request, pursuant to your authority under Chapter 40B, that be formally waived. To answer the other question, I'm sorry.
Sorry. Go ahead, Stephanie. The only thing I was going to highlight too is, just so they all have it, as Jeff has indicated, these plans were submitted and reviewed throughout the approval process. They were then submitted again to issue a building permit. They were then again reviewed against to issue a final certificate of occupancy. So under 3 distinct review processes, the town of Bridgewater went through, reviewed our plans for the approval, reviewed the plans to issue us a building permit, and then came back, inspected the building, saw the conditions as they were presented in the plan, and it issued us a certificate of occupancy. At no time through that entire process and 3 discrete review process was this lodging provision raised. It was raised 6 or 9 months after that. As Jeff has acknowledged, and in full disclosure, we did have some issues with some rowdy tenancy early on. It was with a different management company. We terminated that management company. We have a new manager who also manages another property for us in Scituate. They're very diligent. As Jeff indicated, I think you could speak to anyone at the
Justin, I don't mean to cut you off. We're not debating that. I mean, I think the concern that the members have is that you lost in the lower court. Now you're on appeal. 3 justices chuckled and said, maybe you should just go back to zoning, which you might have the right to do. I think, you know, as I stated, I'm not speaking for the members, but I'm trying to expedite this, is that given the fact that there is ongoing litigation, given the fact that if these 3 members, one of which is vaguely familiar with this, 2 other members weren't on the ZBA at that time, completely undoes the direction that the town took in taking legal action. I think that's where they're uneasy, and that's, I think, a pretty high ask of these people. So, I mean, that's the concern. And beyond whether or not they even think it's a minor modification.
Yeah. All right. Well, that's fair. But the question is, you know, this board has the responsibility to act on, you know, this request and comprehensive permits in general, and to use their reasonableness. I mean, as my partner said, the fact that we're being identified as a lodging house for having
we're not going to try the case here.
But that's the issue.
No,
this is not a lodging. Justin, let me finish. This is not a lodging house. It's a multifamily apartment building. There's a million places in Bridgewater that have 4 unrelated people. And I know that's not in question tonight, but we're asking for the zoning board to understand what the provision is, to look at what they approved. It may have been a former board, and members that are sitting now were not involved. We understand that. But to consider, is the lodging house provision applicable? It never was raised by anybody, by this board.
Again, I don't think nobody's debating that.
Well, I think that.
Okay, but within, I want to say one thing if I can. Within the purview of this hearing, the obligation of the board is to determine whether this is a minor modification and whether they approve it.
I'm sorry,
Just to determine if it's a minor modification or a major modification, right, and if a public hearing is necessary. That's really what we're here tonight.
Right.
So
Thank you, Jeff.
And so if I may, just very quickly on that point, I think that Jeff's point and appreciating that the members here weren't on the ZBA in 2019, 2018, the plans that were submitted and approved, the architectural plans, they did very clearly demonstrate that the number of beds was going to be 2 per bedroom. And in addition to the architectural plans showing that, in addition, there was a table on sheet 2 of the approved architectural plans that the zoning board approved. In addition to that, the zoning board reviewed and had peer reviewed a model lease that referenced.
We heard that already.
Respectfully, yes, respectfully, that and respectfully, that is your argument, both at the, with the Superior Court, and I suspect it'll be your argument in the appeals court as well, when you're addressing that in the appeals court. So my concern here, though, is, as Bob stated earlier, is that you are trying to circumvent the legal system here and trying to get your ultimate relief here coming back before this board. While you may have the ability to do so and have the ability to come before us and have this argument here and present this argument, you're re-arguing or relitigating what is already in the process of litigation here.
Madam Chair, respectfully, I'm not sure how we're trying to circumvent the legal process when the Superior Court justices themselves recommended that we file this modification request. So there's no end around. We're taking
Is
the
that
guidance
in a
of
written
something.
decision they said that, or that
No,
was
they
from the
said
bench?
it's on YouTube that you can look at
Yeah.
the appeal that we made and their recommendation to go back before you and to raise this issue. It's not, I'm not making that up. You can, don't take my word for it. You can
But my
review it.
question is, have they issued a decision?
No, they
So
have not.
then that's meaningless to me.
Well, but again, there are two different purviews, as
Yeah.
Stephanie highlighted. One is with regard to an enforcement action after a building is built by a building commissioner. You're the zoning board of appeals. Your prior zoning board approved what we presented. Not only did that happen, but as we've said, you issued permits to build it and you issued permits to occupy it under those plans. But outside of that, one is an approval process for the rights within the building. The other is an enforcement action. That enforcement action is through the appeals court and through the building commissioner. This is the request of the ZBA. We're not trying to circumvent anything. We are
But
just
the
exercising our
conclusion,
legal right
if
to the
the
appropriate
ZBA
process.
was to agree with you, the conclusion is the same conclusion that you were trying to achieve in court. Correct?
Correct.
Yeah.
Well, the
So
only
we
reason
would
we're trying to
wait,
achieve
so we would ask,
so
we're not gonna, well, I think we've made the determination that we're not talking about the merits tonight. We're talking about if the board thinks this is a minor modification or not, and if it's not, wants to hold a public hearing. Correct me if I'm wrong, Bob and board. I think that procedurally is what we're asking for tonight. If a public hearing is deemed that this is not a minor modification and a public hearing is scheduled, we can continue with the discussion at that time. But tonight, it's before the board. Is this a minor modification or not?
Dan or Amanda, do you have any comments or questions?
So are you saying the zoning board of appeals has authority over the appeals court?
They're two different
Right,
entities, two different processes. You have
Okay, but if
every,
we issued a decision tonight and the appeals court came to a different decision, which one ruled?
if you
there's two
issued a
paths.
decision, if you issued a decision tonight, the appeals court, I mean, I'm paraphrasing and I don't know this, but my presumption would be justices and whether it's appeals court, land court, they like when litigation goes away. So I think
Well,
they
that
would
would
be
be a
support.
settlement.
No, it's not a settlement. It's the zoning board taking action on something that you have the purview to do we've gone before this board. We go before a million other boards in a million other towns asking for minor modifications or major modifications. So what we're asking for is nothing different. The fact that there is ongoing litigation in a different venue does not give you more or less responsibility on how you're reviewing what we're asking.
And if I
Well,
may just,
I would respectfully disagree with that. There are many instances of, litigations of the same nature being litigated at separate courts, and those courts staying a litigation pending, a different court evaluating those same claims. So,
Well, all right. Well,
so if I
listen,
may just,
Stephanie,
ahead.
yeah.
if I may just jump in here and to kind of address your question or your concern. So what is at the appeals court, again, is it's appealing the Superior Court's summary decision in the enforcement action. And so, I think Jeff had said that the Superior Court justices had said, why don't you just go back and amend your comprehensive permit? It was actually the appellate court panel that had made that recommendation. But nonetheless, the SLV Bridgewater PO was required, unfortunately, once it got a cease and desist, it was required to play out that legal process. And the reality is, whether SLV Bridgewater prevails at the appeals court or whether it does not, the reality is it's still probably going to come back to this board and say, this is a comprehensive permit. We're asking for you to clarify whether or not you thought that the the lodging house provisions apply, and if they do, then to please waive them. And so it's somewhat the same result is going to happen. So it's not an end run, and I don't. People say that and they think negatively, but this is not an end run. It's just the way that 40B works. And so it's been identified that if there is a conflict in terms of what the applicant understands it was permitted to do, and what somebody else applying the comprehensive permit, it makes complete sense to come back to the Zoning Board of Appeals and to say, we're requesting this clarification. And to the extent that you feel that the lodging house provisions, while never asserted during the public hearing process and prior to the issuance of the comp permit, may apply, we're requesting formally that waiver be granted. And so, again, this is just requesting the board to make a determination whether the request for this clarification and grant of waiver, is a substantial change to the project or whether it's an insubstantial change to the project. And as Jeff had
I think we
stated,
understand what the ask is. Again, I mean, I think that I don't know that you're acknowledging the position that the board is in right now, that the town had made a decision to pursue this. These three individuals are being asked to screw that. We think it is or it isn't. I mean, to keep this moving along, I think we're at a point where the board can somebody can make a motion to vote in favor of the waiver or not, or you can continue it and allow the members to speak with our town attorney and get themselves up to speed. So that's how I see it right now. But
Yeah, Bob, the only thing that I would ask, and if we do a continuance or otherwise, because Jeff said it is, and I want to be clear, you can make your judgment. It is the appellate court commentary is on YouTube. It's available. It's public record. The comment that the judge made was not a flippant, like, well, why don't you just go back? It was meant to be a constructive direction for resolution. And I just want to make sure that that's clear. Again, I'm not asking you. You can talk to Attorney Rollins. You can look at it yourself. And again, I'll defer to Jeff and Stephanie on whether we want to continue or not. But I think at the end of the day, that watching just the dialogue on that would be constructive for the board, because again, I think it would actually reinforce that this isn't necessarily an end around. It's taking one court and judges at that appellate level's direction to try to find resolution. Simple as that. If you're willing to indulge us, that's the only thing I'd really ask the board to at least take the time beyond whatever else you want to conduct is to watch that YouTube link. And if you can't find it, we'll find it and direct it on. And with that, I'll stop.
Anna, back to you.
Sorry, my connection, I just lost my connection, so I apologize. Dan, do you have any questions or comments?
Yeah, I mean, my sentiment is basically the same. I think the only thing that I'm struggling with is whether or not, at the end of the day, I feel this is, a major or minor modification, and I think some of that needs to be qualified. But again, it's really coming back to the pending legal implications of this, and I don't necessarily feel comfortable with that right now. I also have concerns like, is this something that under 40B, are you even allowed to rent by the bed under 40B?
Of course we are.
So those are things that, I'm not 100% familiar with. So if we were to get to that point, that's something that I would need more information on, and I would like to go down that road, but I don't even know if I'm there.
Yep. And just for your background on that, as you do that research, so this is comprehensive permit at state level. The lodging is a bylaw that is local because we did not believe the bylaw applied to an apartment project because under that statute, if you have a lease, a lodging house definition is short term, no lease. Your premises are not defined. You share a lodging house, not have a unit, not have a lease. So I just want to clarify, I'm not selling you, I'm just saying as you investigate, the differentiation is we didn't believe we needed to ask for the request because we never felt we met that standard because under the face of just a 40B, it is a 40B apartment project. It is defined as an apartment project. It is not as defined as a lodging house. So at the end of the day, the lodging house at the town level's provision had this restriction for the purposes of a lodging house that doesn't have a lease, doesn't have a duration, doesn't have defined space, was okay. That's the provision they tried to apply to us. We didn't have it. We didn't think on its face we had a question of whether we qualified. So that's the differentiation, high level. Again, act further on that, but that's why one is a comprehensive permit, state level, wouldn't require us to ask, wouldn't require us to waive it unless we thought it was applicable. And for those reasons, we didn't think it was applicable because it was never raised by the prior ZBA board
We
or
got
the
it.
building.
Yeah, yep.
We got it.
Yep, we got it. Thank you. Amanda, do you have any other questions?
No,
So do I have a motion from either Dan or Amanda?
I will motion to stay this issue and continue it until the ZBA can address these issues with the town's attorney.
Do I
And
have a
I'll
second?
second that motion. Yep.
Dan?
Yeah,
All in favor? Aye.
Yep, aye.
Amanda?
Aye.
Myself, aye. So, with that, the motion to stay until we have the opportunity to discuss this further with the town attorney. And then we can, I don't know when we'll be able to do that. So Bob, I don't know.
Yeah,
when-
well, I'll communicate with everyone on the other side in terms of dates.
Okay,
So we'll just wait to hear from you, I guess.
Yes,
To be clear, so the board is taking no action this evening.
the board voted to continue it. So no act, that is their action.
Thank you.
The only other request I'll make is when this was submitted to us, you dropped off the paperwork with just your name on it. There was no email, there was no mailing address, there's no phone number. Not the most professional way to handle it. I mean, we had to scramble because we were very aware of that there was notice requirements and date requirements. So if you're going to communicate with us, communicate us in a professional way, please.
Noted, Bob. You and I have exchanged emails in the past, in the not too distant past, and I think everybody in this town knows how to get in touch with me, but we'll make sure future correspondence is on letterhead and that an email and a phone number is included.
Thank you. I think, Amanda, you might be looking for a motion to adjourn.
Can you just approve the 2026 meeting dates for me?
I don't know that they had an opportunity to look at those. We're going to have another meeting, Nicole, so we can do it then.
Okay.
Thank you, though.
Okay, I will motion to adjourn this meeting.
Well, second.
Amanda,
Aye.
Dan,
Aye.
myself, aye.
Thank you, everyone.
Thank you.
Thank you.
Thanks.